The next matter to come before the court this morning is Thomas Darno versus Westfield Insurance Company. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve that time, if you let me know when you get started, I'm keeping the clock and can keep you apprised of the passage of time. The court's read the briefs and we're ready to proceed when you are.
Great, thank you. I will reserve 3 minutes of my 15. May it please the court, Jim Falvey on behalf of Thomas Darno, appellant in this matter. As you know, having read the briefs, this is our second time on this case. The first time the case was remanded back to the trial court for more facts to be vetted out, for more determination. And the argument that we're here for today, to me, is almost wholly a legal one. I don't believe there's much in terms of factual dispute in terms of the facts of November 13th, 2010. So what we're left with really is a question of whether or not Thomas Darno was occupying the vehicle. As has been noted, and I think the court's previous decision here in the briefs, that this case is essentially the opposite of most of the cases that have been heard in this court and the different appellate courts in the state, in that typically occupying has been used as a vehicle for coverage on these UIM policies. In this case, it's the opposite, where if he's occupying the vehicle, he's excluded from coverage. So the issue as we see it is twofold. The first part of the analysis, what's the plain meaning of occupying? The Westfield policy defines it as in, upon, getting in, on, out, or off. It's our position that Tom Darno was doing none of those things, that under the clear definition of occupying, and under the occupying as defined by Westfield, he was not in the vehicle. He clearly had gotten out of the vehicle. The vehicle stalled on State Route 45. After it had stalled, he and his friend Jacob Parquette were pushing the vehicle, get it back off the road. So the vehicle comes from off the road onto 45 and is facing essentially, I think that would be east. So they wanted to push it back off the road to the direction it came, which would be the west. Mr. Parquette gets in front of the car to push, and Mr. Darno essentially gets inside the door to push it that way. So they got the two of them pushing the vehicle off the road. Mr. Parquette sees the vehicle coming down 45, notices it, can't really tell how far down it is, thinks they have enough time still to push the vehicle, looks again shortly thereafter, and notices the vehicle is now very close, doesn't believe they have time to move the vehicle. He tells Darno, run, he runs the other direction, and Darno is hit by the other driver. So in that sense, he's not in the vehicle, he's not upon the vehicle, he's not getting in, he's not getting on, getting out, or getting off. He's out, he's off, he's pushing the vehicle. Now, the cases typically that have looked at these occupying cases have looked at, well, could the term occupying have more than one meaning? Is it susceptible to more than one meaning? And generally to do that, you have to look at the facts of the case. Some cases it's pretty straightforward, whether or not a person is in, on, getting in a vehicle. You know, if someone's sitting in a passenger or driver's seat and they're hit by another vehicle as they're driving, I think it's pretty clear they're in the vehicle. So you look at the facts of the specific case, and our position is the facts of this case, Mr. Darno was doing nothing that would be considered occupying the vehicle. If there is a question as to whether or not he's occupying the vehicle, then it's the ambiguity would be construed in favor of coverage. And we cite a lot of cases, 9th District cases, Ohio Supreme Court cases, that have found just that. If there's an ambiguity in the insurance contract, the ambiguity is determined in favor of coverage. So our position that the trial court's decision for it to stand essentially has to, it doesn't make the determination, but it has to essentially be making the determination that Mr. Darno, in pushing a vehicle off the road, then running from it, and there's no dispute he was running from the vehicle as he's hit, that meets a clear definition of occupying, which, for the reasons I've stated and for just the basic facts of what happened, that doesn't make sense. It can't be that that's a clear definition of occupying a vehicle, someone running away from it. Now, there is some, in my estimation, confusion because of all the previous cases that are talking about occupying and defining it or looking at it liberally, broadly. the reason for that is because those courts, and this court has made decisions in that regard, those courts are looking at from the opposite end of the spectrum where occupying is a prerequisite for coverage. In this case, occupying eliminates coverage. So we've got a body of case law out there where the courts are saying, well, you've got to look at these facts, you've got to look at these tests. Is there an intrinsic relationship? What's the relationship with the vehicle? We've cited some of the specific cases, so has Appellee regarding what is or is not occupying under these different tests. They're all fact specific. I mean, we cited some of the 9th District cases. Woods is the case where the man was lying intoxicated next to a vehicle and was shot. And the court said, hey, look, that's not occupying. There was the Williams case where the police officer was never inside of the vehicle, wasn't doing anything with respect to the vehicle. The court couldn't come to a construction of occupying that would include those things. The case here, the Darno case, to me, is essentially liberally construing not occupying. Because occupying is the exclusion. And in this case, if you're going to construe it as anything other than he's clearly occupying the vehicle, it should be a ruling in favor of coverage. And the trial court's opinion on this, like I said, it doesn't really delineate how it came to the decision in terms of I'm finding this is a clear occupying definition, or I am finding that there's a delineation in terms of it's not clearly occupying, but I am going to take the cases that have expanded occupying and say that that somehow has become the law now with respect to whatever the policy says. And I think that's our main disagreement with what I think the court was saying in that, is that the cases that are broadly defining occupying are doing it for the purposes of finding coverage. It hasn't been that occupying has been changed to a broad definition to include all these things in all circumstances. It's in finding coverage in an insurance contract. That's what all the cases we've cited to are referring to, and that's why we think the court got it wrong in this case. And our request would be for another remand to find that this case was back down to the trial court, that there is either a clear showing here that Darno was not occupying the vehicle, or at the very least, there is a question, and that question would be construed in favor of coverage.
Broadening the scope of this a little bit, what is it that makes Mr. Thomas Darno, an insured versus a claimant?
The policy specifically includes bodily injury to family members, which he is, as a son of John Darno. So a claimant to me,
so in any case, if Mr. Thomas Darno was trying to push a cart of apples off the roadway when he was out with his friend collecting apples, and a motor vehicle, a third party comes down and he is struck, is he covered under this policy that his father owns?
I would say he is.
Because there's a language regarding being a pedestrian?
Well, yes.
What invokes the coverage?
Yeah, well, he's not excluded. It's the opposite. I mean, typically, all the other contracts in these cases were, if you're occupying another vehicle, I believe that would be the reason why they had that language in there. You had to be occupying another vehicle for there to be coverage for a UIN case. In this case, it's the opposite. It's as long as you're not occupying another vehicle, then there's coverage.
You're not excluded.
Right, you're not excluded. Right.
I'm trying to get where the universe of this coverage is versus down to the specifics of the case. So if Mr. Darno was skydiving and he was injured, would he be covered under this policy? I would say no. I would say no. Okay, why?
Because a skydiving injury is not caused by an uninsured or underinsured motorist. That to me is the difference.
So if he landed on the road and was hit by a car, now he'd be covered?
Assuming he survived the fall. Yeah, I mean, it's that's the difference I would draw. And I mean, I understand that I guess, I feel like I'm back in law school, some of these.
And so did I when I was revisiting this case.
That to me is the difference. It's the uninsured, underinsured portion of policy. So it would cover injuries sustained via uninsured or underinsured motorists versus some other mechanism of injury. Okay, good. Thank you, Judge.
Good morning. My name is David Utley. I represent Westfield Insurance Company. It's important to remember in this case that the clear and literal words of the policy define occupying as in, upon, getting in, on, out, or off. The policy does not define occupying as in, upon, getting in, getting on, getting out, or getting off. Therefore, because Mr. Darno was out of the vehicle in a reasonable geographic proximity to the vehicle, doing a task associated with the vehicle, he was occupying the vehicle, as all of the case law demonstrates in this case. Moreover, because Mr. Darno is not the contracting party in this case, he is not permitted to have the policy construed in his favor, as the Supreme Court told us in Westfield v. Gladys. Therefore, this court should look to what other courts have decided the term occupying is defined as. And as we discussed in our brief, occupying is defined, as we discussed, when someone is doing a task reasonably associated and geographically associated with the operation of the vehicle. There's no question, when this court sent it back, we went and got the evidence. Mr. Darno was struck 2 or 3 steps from the vehicle. There's no question that he was occupying this vehicle, and Westfield would ask that this court affirm the trial court's decision.
One of the appellant's arguments that when, in the prior case law, construing the term occupying, which was found to be ambiguous in several circumstances, that it was with a mind toward coverage versus exclusion of coverage. Is that a distinction of difference?
I think it's a distinction without difference. Those cases all talk about the definition of occupying and deem and define what occupying is. And this court has addressed those terms throughout the years. And as a matter of fact, the Supreme Court has kind of adopted a universal standard in the Joins case. The immediate relationship the claimant had to the vehicle. And there's no question in this case that young Mr. Darno had an immediate relationship to this vehicle. He was driving the vehicle when the vehicle stalled, and they got out of the vehicle and were attempting to push it off the road when this accident happened.
Was the court in the Joins case reviewing a term related to coverage or to exclusion?
I believe, and I don't know for sure, Your Honor, but I believe they were, I don't know, I don't want to misspeak.
Okay, we'll look at it.
Thank you.
It almost sounds like the joints standard is almost like a but-for type of situation. But for the involvement with this, and I don't know if that's correct or not, but for the involvement of this other uninsured vehicle, you would have not been in a place where you were struck by an underinsured, uninsured motorist.
Certainly, but for the fact that you were operating a vehicle that you owned that was not insured on our policy, we would have provided coverage.
Of course, the Westfield could have written that into the definition.
We did, in the other owned auto exclusion, that's what we're talking about.
Well, I'm speaking specifically to the definition of occupy.
Well, we did, when we said out, on, out, or off.
Well, there's a question, or actually I'm not even sure that there is a question as to whether Mr. Darno was on or getting off, the testimony, as I understand it, was he was running away from
He was
the
out.
vehicle.
He was out in geographically and intrinsically relationally related to the vehicle.
Well, but does that ignore the testimony of the witness who was deposed, who said, I saw these lights coming, and I said, I don't know, was it Tom? I said, run, Tom, and he ran away, and I heard that he was hit within a few feet, no question, in proximity
Right.
of the vehicle, but he was running away.
Right. I'm sorry, you've lost me, and I
Well,
apologize. for that.
I'm trying to tie in the facts that were testified to that specific definition of in, on, or getting in, or getting out, or getting off.
The Supreme Court tells us in Jones, the determination of whether a vehicle was occupied at the time of an accident should take into account the immediate relationship the claimant had to the vehicle within a reasonable geographic area. In this case, the immediate relationship that they had was he was driving the vehicle, then he was pushing the vehicle. And we cite to a lot of case law in our brief where they talk about repairing the vehicle, trying to fix the vehicle. That has been held by this court and other courts to constitute occupying. Reasonable geographic area, 2 or 3 steps was the testimony from young Mr. Darno's friend.
Judge Henson's question before, though, if he'd been shoving apples off the road and was hit by a car,
Without any relationship to the vehicle that he owned that wasn't insured on our policy,
yeah.
then we would have provided him coverage. He would have been an insured on the Westfield policy by virtue of his relational status with the named insured, the contracting insured, his father. With respect to the skydiving question, I will agree with Mr. Falvey that, well, if he was run over after he fell, certainly that would have been an uninsured or underinsured motorist claim. The reason there's no coverage in this case was because of the other ungodly exclusion, which, again, as the Supreme Court told us, you have to look at the intent of the policy. If there are no further questions, I think I'll sit down. Thank you, folks.
Thank you again, Your Honors. 2 points I want to just talk about briefly in my 3 minutes here. The Joints case, the Supreme Court, it's a child exits his grandma's vehicle and goes out in front of it, hit by an underinsured vehicle, and court found an ambiguity and found for coverage. The Joints case is for, that's where all the cases after Joints come, looking to see, is the term occupying ambiguous, and looking if it is ambiguous to find coverage. Whether or not it's ambiguous, I guess we disagree on what occupying is defined as in the Westfield policy, but in, upon, getting in, on, out, or off. I read that as in or upon, or getting in, getting on, getting out, or getting off. They're saying it just is getting in, on, out, or off. I would suggest if that's the reading, occupying then serves as a full bar to any kind of UIM claim, because you're either in or out, on or off of the vehicle. It would serve as a full exclusion, which could certainly be written as a full exclusion. The way occupying is defined in their policy, in, upon, getting in, comma, on, comma, out, or off. To me, that can only be read as getting in, getting on, getting out, or getting off. If it's in or out, on or off, it's a full exclusion. The cases are all, joins in the cases all after, all the 9th District cases. They're all talking about if there's an ambiguity, you look for, can it be construed in favor of coverage? If there's an ambiguity in this policy, then certainly there could be coverage in terms of whether or not he was occupying this vehicle. He was running away from the vehicle at the time he was struck. With respect to the argument that he's not an insured. I would just, we've cited the cases on that point in our, I think our reply brief, but the case, I think it's the Eder, the second district case, it's similar circumstances in that it's a gentleman pushing a car off the road. The court in the second district finds in favor of coverage on his grandmother's policy. I think it's very instructive in terms of similar set of circumstances. The only difference is in the Eder's case, we've got occupying as a covered act versus occupying as an exclusion under the current policy. I think that to me is the difference without a distinction. It's still a liberal construction of the policy to be found in favor of coverage. Okay. Thank you, Your Honor.
Thank you both for your presentations this morning. The court will take the matter under advisement and issue a written decision which will be mailed to both sides as well as posted on our website and the Ohio Supreme Court website.
Thank you.
Great. Thank you.